evening, everybody. Welcome to Reasonable Doubt, sponsored by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Damon Parrish. Tonight, we're going to be opening our brand new season of Reasonable Doubt. We're going to be kind of starting a little new format. We're going to go to more of a group discussion, a little more of a round table, and our guests tonight are going to be criminal defense lawyer Jason Luong and assistant public defender Eric Davis. Gentlemen, I want to bring y'all in this evening and just get right to it. We're going to be obviously, we're going to jump right in because we got a lot to talk about. There's a lot going on. We're going to be taking your calls about 8:30. We'll put the phone number at the bottom of the screen. We're also going to be taking questions on Twitter all night long. The Twitter handle is at HCCLA_TV, so please send us your questions. Like I said, we've got a lot of topics to discuss, and Damon, welcome back for a new season. We're bringing you back, my friend.
Hey, thank you.
And I'm back as well.
Right.
So we made the cut.
All right.
Brought back. That's a good thing.
Season 2 is going to be a good season?
I hope so. I sure hope so.
I think it will be.
Eric, Jason, we are
Evening.
very glad to have you along, and I want to get right into the big story of the week. Obviously, is this Waco biker gang shootout and all the problems that seem to be fraught with it, and what we're learning. Obviously, Damon, we learned a lot just in a short amount of time here since the incident, haven't we?
We've learned a lot, and we will continue to learn a lot. And the more we learn, the more disappointed we will be. That's how it is.
I can't agree with you more. First thing I want to turn to, and I kind of want to talk to you, Eric, first about this. I want to put this out there to you, is they're going to have a lot of challenges prosecuting this case up in McLennan County just because of the sheer volume of defendants and the lack of resources that county has, and what I understand is essentially a lack of lawyers potentially to take this case if they're indigent.
Well, that's true. They'll probably have conflict situations in terms of getting lawyers to represent the defendants. In all likelihood, they may look to neighboring counties, or it may even look as far as Harris County for lawyers to potentially represent the defendants in that particular case. But I don't think that's as much of an issue. And I think ultimately in this case, they'll probably be very selective as to which defendants are actually prosecuted, because some of the defendants may be facing more serious crimes than some of the other defendants who are being charged in the case. Because you may have 100-something people who are being charged, which is a surprise, but of those 100-something, there may be some who may be charged with murder cases and murder counts, and those defendants will probably get priority, and the other defendants may not even really ever see the inside of a courtroom in terms of a trial.
The biggest issue I see here right now, initially, guys, is every single one of these 170 people are being held on $1 million bond.
Right. Right.
What's the first steps? What do these people got to do to rectify that?
Well, first, obviously, they need to get some sort of legal counsel. We've talked about the difficulty of how do we assign all these folks if there's a shortage of the small county, whether they have lawyers. But this kind of feels like what happened in the Kmart situation with the court systems don't like a dragnet that nets a lot of people and everyone's treated the same. All these folks are going to have different versions. Some of them, I wasn't involved, I wasn't there, but the bond situation is supposed to be individualized, and clearly it's not being individualized in this case, so they're going to have a good shot at getting it reduced, but it's a matter of getting a lawyer first, then moving the proper procedures with the court to get the appropriate bond and see if the judge is going to uphold these bonds at this amount. But for 173 people, you think logistically, how are they going to do that?
Where are they going to find the time to process these people through for a bond hearing?
And actually, Jason, I'm going to disagree with you on that one. I don't think the first step should be they get a defense attorney. I think within 48 hours, you go before a magistrate and an appropriate bond is set. You can't tell me that $1 million bond for somebody you know is not charged with murder, you know it's not charged with a capital offense, is appropriate. I think the first step should have already have occurred. They should have went before the magistrate look and say, hey, this is a third-degree felony, maybe. This is a misdemeanor, maybe. Let's set this appropriate and move on.
I don't know I haven't seen the indictments or the information for these folks, the charging documents, but I think in the papers it sounds like they charge every single one of them with the same charge, with this engagement in organized crime activity, with the underlying offense being murder or capital murder, which means, then they are being charged at this super high level offense. But again, I agree with you that needs to be individualized, and whether or not the judge there is going to have the willpower and even the resources to really make the decision as to who was at that administrative level of bond hearing to make those decisions, it's going to be interesting to tell. Well, I don't know how many judges they even have in McLennan County.
Yeah, I haven't even had a chance to look at that.
They have any judges. They have just executioners.
Well, but you said something that struck me. It is the murder and capital murder charges is the underlying basis for the engaging in organized criminal activity. Just today, we're getting stories in the Austin American Statesman and stuff about how that it's really more, what it's looking like is a police massacre, that the people who actually did the shooting and the killing in this case were the police, not the other bikers.
Right.
Yeah, I think right now it's too early to really figure out everything, and I think that's why they responded the way they did. Now, I'm not saying that that's right, but they're going in and just charging people, and they're going to ferret it all out later on. And that's been my experience in handling cases when I did handle cases in areas like Waco and some of those smaller counties, was that's what they did. They charged people first, figure it out later on. You know, here in Harris County,
Texas, of shoot first, ask questions later.
Yeah, absolutely. And you'll see a lot here in Harris County, for example, unlike other smaller counties. If a defendant is charged in a case, he's going to court, and you're figuring all of that out. In some of those smaller counties, what will happen is that a defendant will get charged with a case, sit in jail, and then the prosecutor will figure out who's going to indict, who is going to be charged, and then some of those people will be released without going to court. So in that situation, in that county, a lot of those folk will have their cases resolved or dismissed without them ever seeing the inside of a courtroom. They're going to figure it all out at some point in time. They may get it wrong, and they may do it without the help or assistance of an attorney. Because a person's not going to get a lawyer. And for example, in Fort Bend County, if a guy is arrested and he's charged, he's not going to be appointed a lawyer until he's indicted. And in McAllen County and those other places, they won't appoint him a lawyer until he's indicted. So we're talking about the shortage of lawyers and this being an issue. That may not even be an issue depending on who they charge in the case.
But those guys are going to sit in jail for bonds they cannot afford.
That's
they
right.
Can't post.
Unless they hire a lawyer.
Unless they hire a lawyer.
To go in and talk about the bond, or they write a motion out themselves asking for a lower bond. That is correct. That's what will happen in McAllen County. That's what happens in all cases. It's interesting, we're outraged when it happens in this case involving a bunch of white bikers, but when we have African Americans who face that all the time, nobody's outraged.
Don't get me wrong, I'm just as outraged. But now we have a way that the people can be sympathetic to it in other ways.
See what the situation
see what's going on.
Absolutely.
And that this is not right.
And you make a good point, Eric, that's been talked about this week. There's an NPR article about the racial juxtaposition that we have with this versus Baltimore and versus Ferguson. And you know, look, the bottom line is people can manipulate photos to look however they want. And what's been done here, I don't know whether there's manipulation or not, but the suggestion is that you've got a bunch of white bikers who have just been involved in this giant shootout, and they're just kind of sitting up on the hill, and cops just kind of standing guard. Whereas it's on the right side, you've got this picture in Baltimore of, you know, riot gear, SWAT team throwing tear gas, AR-15s coming at them.
Right.
Is this really an issue, or is it something that's being fabricated?
Oh, man, I think it's an issue. I mean, you know, some people live it every day, and we'll look at it and know it's an issue in terms of the disparity and difference in how people are treated. And sometimes the difference in treatment is based on race. You know, and I'm not a race baiter or a poverty or race pimp or any of that, but I'll tell you, when I first moved to Houston, I saw it. And I was kind of surprised because Houston's a cosmopolitan, a big city. It's a city that I would argue is progressive, you know. But I mean, I've lived it and seen it. And I think most African Americans, even professional African Americans, can say that they've lived it and seen disparity in treatment. So, I mean, I don't think that it's just this myth or manipulated or it's just people's perception. But the reality is that there's a difference in how law enforcement approaches African Americans or people who are minority as opposed to someone who isn't.
Well, and on that note, I want to ask you about, because kind of the facts we're hearing here is that police had been warning this Twin Peaks about this, trying to get them to stop, don't invite these bikers, and that just before this shootout occurs, that you've got, you know, gobs and gobs of cops, you know, on the sideline basically waiting to charge. And ironically, this happens in Waco, you know, almost 20 years later,
right,
to the same thing that the feds did with the Branch Davidians. They're kind of sitting, waiting, and one thing is the spark. So that's why I really question, is race really the issue here, or do we have a situation of, you know, some cops really kind of setting up and manipulating the issue?
Well, I think race is the issue, or part of it, not just in the way it laid out, but in the way they prepared for it and how they've dealt with it. When you have officers in full riot gear and smoke grenades and AR-15s for a protest, right? But then you have 5 different biker gangs. Some are peaceful, some are not, but you have identified gang members. You can't tell me a situation where the Crips the Bloods, the Latin Kings can go to Twin Peaks and sit down for a supper, and the cops would sit outside and just wait. I don't believe that will ever happen. And so I think in the way they dealt with it, the way they prepared for it, and in the way it's being covered by the media, you know, outlaw. We aren't using the harsh words as thugs and all that kind of stuff you saw when things happened in Ferguson, things happened in Baltimore. So I do think that there is a race component to it. Maybe it's not intentional. It may be subversive. It may be like you don't know you're doing it, but you are in fact doing it.
But the Banditos, they aren't an all-white gang, are they?
No, Banditos.
Yeah.
Right.
So that's why I kind of question about the reality of this, you know, comparing the two and whether it is a fair comparison or not. I mean, you've got all these national media out here comparing it, trying to make a story where I'm not sure there really is one. And I mean, we saw a video on YouTube that was released just last week about, and you know, we in Texas right now, we've got the legislature considering open carry.
And you know what's interesting? That even though this happened, the legislature seems to be undeterred.
Undeterred.
Right? And part of the reason why they're undeterred is because they don't have that same fear. If it were a situation where you had the Crips, the Bloods, and everything, and that all happened, the legislature would be like, oh, we can't do this. We can't let them have it because of the fear factor that's involved. And I'm going to tell you, the police have a different fear factor. The Banditos are not an African-American gang, or, you know, they're not predominantly Latin. They have some Latin members in their gang. And, of course, they're not an all-white gang because of that.
Right.
But the hue of the people isn't quite as dark as the hue of the people that are in Ferguson, the hue of the people that are in Baltimore.
Right.
The hue of those folk is pretty dark. And police officers approach people differently, more aggressive, with fear when they deal with those types of people. And, you know, as a result of that, as a result of them dealing with African Americans, as a result of them dealing with darker hued people, they approach it with fear. And our legislature and people in Texas, they also approach those instances with fear.
And I think that YouTube video that came out last week is a perfect example of that. For those who haven't seen it, there's a video on YouTube in Oregon that kind of chronicles the difference between the same law, open carry law in Oregon that's going on right now, and they show the difference between a white man who's carrying an AR-15 and a black man.
Yeah, the black man, the officer pulls his service revolver, doesn't ask any question, immediately, and keeps it on him the entire time. He goes down to the ground, you know, and he's got his hands spread out, and he's on the ground. The officer still has his service revolver pointed at him. Other officers come in, separate him from the weapon, and he's still pointing his service revolver at him, still pointing his gun at him. You know, whereas the white guy, he comes up, and the officer comes up, has a discussion with him, a conversation with him. Never detains him.
It is just amazing to me, and you know, we have the Baltimore situation obviously unfolding, and we just got the indictments today.
Yes.
What I find interesting, the cops in Baltimore were indicted, and Damon, you forwarded this to me as
Right.
the news broke. You sent me a text right at about 5:30 saying they've been indicted.
Baltimore 6 got indicted.
Yeah. So I was looking over it, and what's interesting to me is they all talked about how everybody was going to get charged with murder. But only the van driver, the black van driver, is the only one charged with murder. He's up in the top left-hand corner of the screen. He's the only one charged with, I guess, under Maryland, what they call depraved heart murder. Mm-hmm. I'm trying to figure that one out. Can you guys help me with that? At all?
What were the other? I don't know what the other 5 had been. What were they indicted with?
They were indicted on a variety of charges, from manslaughter to violation of official acts type thing, but he's the only one that got a murder charge. And I'm still trying to wrap my head around that.
Well, you know, I think when we look at these situations involving race from a bird's eye view, we have kind of a principled kind of what we would want to happen in society. But we all know this, that all politics is local and all juries are local. And so what the grand jury heard is going to be different than perceptions of what we see in the abstract, but when they hear the evidence, it's a lot different when you hear it individually. We know we talk about, we wouldn't make a we wouldn't make a biasness, or we wouldn't misperceive danger based on simply racial profiling. But when you hear the evidence and you're a juror, you know, your perception is different because it's much more individualized. I think that may have what happened here, because we have a view of like, well, that's weird. In a global broad brush stroke, why would the black guy get indicted for killing a black guy? That seems weird. But the evidence is, we didn't hear the evidence, right? We don't know.
Yeah,
and if we are being really racially neutral, that shouldn't matter that the driver is black.
Right?
It shouldn't.
Yeah, if it's being racially neutral, absolutely.
Sure. And I think they got indicted in part because they weren't in Harris County. You know, if it were here, none of them would have got indicted. No. You know what I mean? There would have been a bunch of no bills handed out.
Right.
Harris County.
Yeah.
The driver was indicted on second-degree depraved heart. The rest were indicted on second-degree assault charges. Of course, as murder, he faces 30 years in prison. The others up to 10 years in prison. So they all 6 got indicted on a second-degree assault and reckless endangerment, but he got depraved heart.
Yeah, you know, truth be told, even though I may not like what the police and I may not like what the police did in this particular situation, I mean, indictment really is just notice. All it is an opportunity for them to know what they're being charged with. Nothing has been proven. You know, it's just a handing down of just basically an information from a grand jury saying, hey, there's enough evidence for it to go forward. We think that there's some probable cause, some reason to believe that maybe a crime has been committed in this situation.
Right.
You know, maybe a crime hasn't been committed, but at least it'll go to a jury and a jury can decide. They'll have the day in court. All the indictment does is just give them notice. It doesn't mean that they're guilty of anything. So I don't know what happened. I wasn't there. I don't think any of us were there with Mr. Gray in his situation. So we don't know what happened. And that's something that a jury will have to decide. The fact that they were indicted just gives them an opportunity to know what it is that the government's trying to prove. Now, why the prosecution sought what indictments they did, I don't know. I don't know what evidence they think they can prove. I don't know enough about the case to be able to say that. I've only heard I only know what I've read and heard in the media.
But this is a cynic in me, is that obviously the prosecutor controls the presentation for the indictment. So maybe I am being cynical, and the prosecutor says, you know what, I'm going to show how race neutral I am in this proceeding against these officers.
And go against the one black male.
The hardest one, because how can you say I'm being, this is prejudicial or being motivated by race as a politician if the harshest punishment is being sought after the one black defendant?
If your theory is true, then all
I'm
the
just
more
being-
reason
I'm
for
just
that
being-
prosecutor to be removed.
I know, I'm just being cynical, but you're never going to prove that unless there's some smoking gun email.
Well,
Yeah,
of course.
But it's one of those things that
It would matter if each case was sort of how she presented it to the grand jury in terms of the different cases, and if she used the same grand jury in handing down all those indictments. My guess would be it was the same grand jury that handed down all those indictments, and that grand jury knew the evidence against each particular defendant. So unless you
But
just have a
they
whole bunch
slant it. I mean, the prosecutors slant what evidence is presented. Right?
certainly only the prosecutor goes in.
I've heard it. I mean, in the abstract sense, I've heard that might happen sometimes.
Jason, that's not true.
You
They
never
don't.
did that as a
Jason, you never did
prosecutor,
that.
Actually, I don't think I ever did, except when the situation was like, look, and this happens in Harris County. This is a broad brush statement, but we need to let prosecutors make more discretion. But of course, that comes with abuse, and they have to have oversight. But yes, I think it might have happened once or twice and throughout Harris County and everywhere. That's the problem with a system based on human judgment.
Yeah, and an indictment, oftentimes an indictment isn't based on the grand jury seeing any evidence. Sometimes it's based on them getting a summary of the evidence from the prosecutor. And so in terms of slanting, now, the word slant makes it seem as if you got this nefarious motive, but you may have a prosecutor who just presents just enough information to get the indictment, answers just the questions that need to be answered. And if you don't have an aggressive grand jury, because some grand jury members are pretty aggressive, and a prosecutor may come in and they'll ask questions, and they're pretty independent, have that feeling, and they will shut down. The prosecutor says, no, we're not going to hand down an indictment in that case. That happens sometimes, rarely, but sometimes that can happen.
I'm curious how they pick grand juries out there. They do the same.
Probably not the key man, not like it is in Texas. I don't know.
Not how it is in Harris.
But to Eric, to your point, do you not think it's kind of nefarious to only present what you know you need to present to get an indictment and not present the entirety of what you have?
I think that sometimes it can also be lazy, too. You may have a lazy prosecutor who goes in and just has her file and may read an offense report to a grand jury. You may have a prosecutor who goes in and actually brings witnesses and goes over a series of days bringing different witnesses. And that may not necessarily be necessary, but it depends on the prosecutor. Sometimes a prosecutor will take witnesses into a grand jury to lock down the witness's testimony in front of the grand jury.
I don't think, does a prosecutor have a duty to present Brady material to a grand jury? I never thought about that. That's kind of an interesting question. What if you had a statute that said, like the same way we have to disclose it, all Brady material has to be disclosed to the grand jury, if not at the time?
That'd be a great idea.
That'd be interesting.
Jason, you have a stack of research and you don't have the answer to that.
I just thought about that when you said, what do they mention to the grand
They don't have an
jury?
obligation to present, unless it shows that there isn't probable cause. If it shows there isn't probable cause, then the prosecutor should present information to the grand jury.
I don't think there's a legal obligation.
Yeah, there's not an
I don't
obligation.
think there's one either. I think there's an ethical obligation to do that.
Because everything Brady should go to probable cause because it goes to the credibility of the witness or the, other than for a mitigation of punishment, but you would think most Brady material would go to the issue of probable cause, wouldn't you?
No, there's probable cause. There may be probable cause to indict an innocent person. You know, probable cause doesn't mean a person didn't do the crime.
I know.
There's just some reason to believe.
But
So
the Brady
this grand
material
jury
should
stuff,
go to the
we give
issue of
too
it.
much credit to a grand jury, and we give too much weight to an indictment. All the indictment is just some reason to believe that a crime has been committed.
But
That's it.
But the point of the indictment is that it changes the course of your. Whether you get indicted or not obviously has a huge impact because you have additional legal fees, you're sitting more time in jail. So the indictment is important. I mean, it's not legally important in the terms of what it means as proof in a trial, but the fact that you're going on with the trial is hugely important for anyone who's charged with the crime. I don't mean to belittle the legal aspect, but most people, if we can get a case not indicted,
Certainly.
I mean, we're high-fiving ourselves everywhere.
Yeah, exactly.
Right?
Yes, we are.
Certainly.
Yeah.
Yes, we are.
Certainly. But in Harris County or in Texas, the function of the grand jury is different than like a petit jury. Or you know how some states actually have these pretrial proceedings where you actually have a hearing and everything prior to find probable cause, and you can really that's not here. In Texas, it's real rote. Yeah. It's almost as if like the DA can write out, this is what happened, and go in and tell it to the grand jury. Have no evidence to back it up, have no police reports, and just tell this to the grand jury and get an indictment. You follow what I'm saying?
I know. I agree.
Let's switch gears a little bit here. I want to get to our next subject that happened this week, and that is the death penalty sentence for the Boston Marathon bomber, Dzhokhar Tsarnaev. Mm-hmm. And we had Catherine Case on this show a couple weeks ago talking about the death penalty here in Texas. And obviously this was an emotional case.
Right.
There was a female runner who went back and completed her run this year with her son by her side. Stayed in town to watch the sentencing, the end of the trial and the sentencing. A lot of emotions in Boston, whereas most of us know the Northeast is a lot more liberal than down here.
Right.
But nonetheless, this was a federal jury, and they sentenced him to the death penalty. I want to kind of talk about that a little bit in the sense that Catherine Case came on this show and said that support for the death penalty nationwide is going down. But I think cases like this are probably the exception, don't you? Anybody on here disagree?
Well, I don't disagree. I think the narrative in that case was powerful.
Yeah.
I think that was a powerful narrative. And I think that case was somewhat of exception in terms of people's feelings about the death penalty. The emotional toll on those families and the way it was communicated to the jury is why a death sentence was handed down. And those complainants, those victims of that terrible crime went to court, and I think the jury was able to see the negative impact it had. And in their mind, I think there was almost a referendum for them to give the death penalty in that case. I think Judy Clark is a phenomenal attorney, and she's had cases where she's been able to control the narrative about the particular defendant.
And this was the first case she lost. And when I say lost, I mean the first one that the death penalty was actually found on her client or assessed on her client. She's had a laundry list. I mean, she's had Susan Smith. She had the Unabomber. She had the guy in Arizona who shot Gabby Giffords, Jared Loeffner. I mean, she's had a number of people in very high-profile cases, very emotional cases, and this is the first one where her client's been given the death penalty.
Yeah, I think this might not be where you want me to go or where you.
I want you to go anywhere you want to go.
But I think there are two things that are at play here. Now, I think more important was her work when she represented one of the conspirators in 9/11. Right. And I think that may have been because at the beginning of 9/11, we may not be where we are now in terms of America's fear of Islam and America's fear of terrorism,
surprise bombing,
and so forth. Yes,
absolutely.
We aren't where we were then. This was a case where you had it all. You had America's fear of the surprise bombing, America's fear of Islam. You had that present in this case as well, and you had not just people who had died, but you had people who had survived the bombing, who the jury was able to hear from and see, which is powerful. Someone loses a limb and they're able to come to court and talk about how this happened, how they didn't die, but they survived, and this will impact them for years later. And then you've got family of victims who have died, and they talk about how it impacted. And then you have people describing the event if it were a situation where, like with Ted Kaczynski's situation, the Unabomber situation, people died. He had victims that died. There wasn't anyone left to come back and talk about the event. Whereas in this situation, she was up against, at least, the defendant was up against people who were able to come in and put a narrative as to that event and then a narrative to the lives of those complainants.
But let me ask you about this. I mean, it's a terrorism case, and I kind of wanted to. I don't think that that support for the death penalty is going to wane in a terrorism case, frankly. Just as what you said. I mean, since that shooting up in Garland, where the officer took down that terrorist, I got to say, I don't think you're going to find waning support for the death penalty on terrorism cases.
And like Catherine K. said, death penalty is not going to go away.
Right.
Support for it will, and maybe with some reform in how we use it and how we apply it. And maybe this case was an appropriate case for the death penalty. I'm not really in support of it, but I agree with you that this case is different. I want to add to what Eric said, not just that you had victims, but who your victims were. They were just people. They're from all walks of life. So it wasn't like I can say, well, it's not me because I'm not in the federal courthouse. It's not me because I'm not her husband. It is just people who were there to either who could run or did run and support, like Boston. And I think when you put the fear of surprise bombings on just everyday Americans, everyday people, you're going to get what you want. I mean, and you're going to get that. And so they wanted death penalty, and she did the best she could do, but that's going to be, that appeals will survive, but appeals will survive and go on, but in the end, this guy's going to die.
Yeah, federal court's a different animal too. It is. It's a different animal than state court in terms of defending a case, as you know.
Oh, absolutely.
Because I don't know where all of her jurors came from, but in most federal jurisdictions, because you'll be pulling jurors not just from a large urban area, but you'll also be pulling jurors from the suburbs. And jurors from the suburbs are traditionally much more conservative.
And in Massachusetts, I think after, you talked about 9/11. But that's where the hijackers got on the plane.
Right.
Was in Boston.
That's not where he was tried.
It's not where he was tried. But that's where they got on the plane. Mm-hmm. And so Boston had people who lost their lives in 9/11, and now they get bombed again. Mm-hmm. I mean, this is a community that's been through a lot.
This was a message.
And this was a message. I feel like this was a message.
I think, I'll just make it, I'm not for the death penalty, I think, but here where we applied it to a 19-year-old, I think we're going to have, it's very disheartening. I mean, I know the nature of the crime was horrible, but with all the scientific evidence that shows the development of human brains and maturity level, I think that it is disheartening that we've applied it to a 19-year-old. I think we may, years from now, look back, when we look back to many of the cases that we use as examples of, I can't believe how barbaric we were in the 1800s applying to the death penalty to 12-year-olds or 13-year-olds,
Right.
I think we may look back and regret it as we understand the nature of science and human development and such. I'm looking at the jury charge they use for the punishment phase. It's interesting the stuff they asked you about, the specific aggregating factors. For example, they talk about whether or not the jury has to find that the Boston Marathon was an iconic event, which is kind of, it's interesting the things that you can factor in on a federal charge on a capital murder case. Things like that, or that he had made messages or sent messages that would encourage future acts of terrorism. So I can understand where they got to that point, but I think that age, it is, I mean, a year and a half he wouldn't have been in it at all. You know what I mean?
But Jason, do you not think that, I'm going to play devil's advocate, you don't think that a 19-year-old, no matter how, can commit a crime so heinous that you are now an adult, you forfeited the right of the youthful forgiveness we would have gave you? Yeah,
in terms of being the sentence you can reach, but I think for the death penalty, the ultimate punishment, I think that it's something that's weighed. And you remember these factors, I don't think you go through all these factors they list in the jury findings, but they don't ever make, for example, they don't tell you how to weigh them. As a juror, you may decide to weigh the iconic nature of the Boston or the lack of remorse. I remember they talked about how they had the one still photograph of him shooting the finger at the camera,
Oh, wow.
During trial or during bringing walk back as being lack of remorse. So, the jurors individually weigh how much each factor has in that. But, of course, I understand that for the terms between the difference of juvenile adults that, you can actually serve incarceration. But for the purpose of the death penalty, I think we may consider the notion of, even though you're an adult, is there a cutoff age in which the death penalty should be applied? I don't know. There's a lot of things that we still are going to learn about 50 years from now review. But I do think that the wave I think that somebody on the news made a commentary that the death penalty may go the way of opposition of gay marriage, that in 10 to 15 years people are going to be against the death penalty. Here, I think it might push that direction because here you had the federal government pushing for the death penalty in a non-death penalty state. And I think that even though I think we understand it, there was also a lot of victims who didn't want the death penalty.
Right.
You know what I mean?
That was, I think, well put, and we do have that movement in terms of age and concern about age. But the one thing that people seem to always ignore is that the only people who are going to serve or sit in a death penalty trial are people who believe in the death penalty.
Yeah.
That's right.
If you don't believe in the death penalty, you're not going to get on a jury. You're not going to be on a jury. You're not going to be in a court. So we may have waning support for the death penalty, but in death penalty trials, the folk who are sitting on the juries are people who believe the death penalty is still appropriate. So, I mean, there can be a support outside the courtroom, people outside saying no. But definitely.
Nebraska voted to end the death penalty, I think, recently over the opposition of a veto.
Yes.
Which is kind of amazing.
It is.
So you may have, I think you're right, as long as the death penalty is available, you're always going to be able to pick a jury that makes it death appropriate or death option.
Well, we've hit 8:30, so I want to remind our viewers we've opened up our phone lines. The phone numbers at the bottom of the screen, or will be shortly. There it is, 713-807-1794. Keep the questions. Those of you who aren't watching the Rockets game, go ahead and call in and send us your questions.
But call in to give us a score, too.
Yeah,
That's
call in
okay.
and give us a score. HCCLA_TV. Keep them coming, guys. I want to get to this case. This one is this is bizarre to me. This Florida sex on the beach case.
Yeah, you guys familiar with that case? It's a silly case.
Silly.
It's a silly case, but honestly, it is silly in that 15 years prison, but I understand the charge. I mean, you should not have sex on the public beach in daylight.
Why not?
Because there are kids. Listen,
Have you been to Miami?
I've been to Miami, and I've been to beaches.
What's your beef?
But I do not want my
Have you been to South Beach?
I've been to South Beach.
Okay.
That's true. And I do not want my 4-year-old or 2-year-old playing on the beach watching people have sex. I don't. Now, do I think that's 15 years in prison time or punishable? Absolutely not. Although in that case, that guy was kind of an overreach because he was a repeat felon, and so he was enhanced a little bit. But
Damon's conservative side coming out tonight.
Hey, man, you shouldn't be having sex in public in front of kids. You want to do it in front of adults, so be it. Whatever. But not on the public beach.
I think it really brings to light the problem with enhancements. For example,
Yes.
And
not
mandatory
that
minimums.
mandatory
Mandatory
minimums.
minimums,
I mean, I
yes.
have several clients who are charged with assault family member, and not that you should ever justify it in doing so, but for what would normally be you spend a maximum of a year. If you've got, it can be enhanced to a 3rd degree, and then if you have 2 even non-violent related offenses, it becomes a 25 to life case. So essentially you're doing, I can't even do the math. I mean, times 25. The punishment is now 25 times the normal statutory punishment for that.
And that's on the minimum side.
Yeah, that's on the minimum side.
Here's the biggest problem I have with this case, the 15-year mandatory minimum, the 15-year sentence, the mandatory minimums in federal court, the enhancements in our state court system. You are giving the prosecutor basically control of the sentence. You are taking the discretion away from the court, and in a lot of instances, the jury. You're just taking that away. In this case, the only reason this guy is not going to get the 15-year sentence is because the prosecutor is withdrawing the reoffender paperwork. That's it. So he is controlling the sentence.
Absolutely.
I mean, I guess I don't mind raising the maximum for a case of repeat offenders, but I do, again, just kind of thought about this sitting here, I would get rid of the bottom. Like, I would not make a minimum anymore. Because, I mean, there get situations, and there have been cases we've all been where the judge is like, I wish I could give you less if you pled, but I can't because unless the state abandons the enhancements. And that means...
It happens in federal court all the time.
Yeah, I mean,
where a judge will say, I just don't think you're not the type of person, you're a good person, you shouldn't get 15 years on this case, but my hands are tied. And it's because these statutes have ceded power to the prosecutors, essentially.
I don't know if I necessarily agree fully. I think oftentimes that the prosecutors can control what happens in the outcome, even if we didn't have mandatory minimums. Think about it. If you've got a case where you've got a crime allegedly committed, there are usually, especially in like Florida, there are usually multiple different crimes that you could potentially charge the defendant with, and there are different ways you can charge the defendant that you can possibly ratchet up the amount of time a defendant can be facing. In Florida, for example, if they used to use, and I think they're still using sentencing guidelines in state courts in Florida, and depending on the number of charges a defendant has, it impacts the sentencing guidelines in Florida. So a prosecutor there still can manipulate the amount of time that a defendant is facing based on how they charge a defendant. And truth be told, a prosecutor can do that in Harris County. You know, by charging a defendant with a first-degree felony or a second-degree felony. There's a lot of discretion still left to prosecutors. And if we don't like what our elected official, our DA is doing, we can vote him out of office.
Well, and the state's right to a jury trial in Texas is also problematic, too.
The right to appeal is problematic as well, I think.
Because that also takes away your ability to, your hands are tied.
We've got a few days left in the session. We can make some things happen. I mean,
Well, to add to that, what it does is it encourages a plea, even when you're innocent. You know, all had clients who were mandatory 25 to life, and all of a sudden they get this 2-year offer, and it's like, well, if I go to trial and lose,
even a 10-year offer is enticing if you think about minimum being 25.
I mean, for sure, but you know, you have those cases where these people are, I mean, they don't want to plead. They didn't do it, and you believe it. And you absolutely believe it, and you fight for them. But at a certain point, they themselves make a decision, man, 2 years is better than 25.
Yeah, fear.
And it's fear.
It's just
I don't want to die in
settling
prison.
a civil case. They're making a business decision.
It sucks.
That happens a lot.
All the time. And it sucks because you, as an attorney, you want to encourage them to fight, but I'm not doing that time, right? And if I get the wrong jury, then crap.
Or I'm not waiting in jail till we get the chance to try the case. You know, that's the hard part.
Exactly. Or you spend 2 years in jail for a trial that would get dismissed the day of, or whatever. I agree. I don't mind raising maximums to a certain extent because I don't think.
I would just get rid of the minimum so that way it's like if the jury wanted to give someone that could be, up to life imprisonment, if they didn't want to start at 25, give the jury the option that look, he shouldn't do 25.
But Jason.
But you don't. I know you. But you don't have.
Wait. We've got judges who are elected to make decisions and use discretion. We have juries who are allowed to hear evidence and within the discretion sentence somebody. When's the last time you were able to sit down and tell your client's story to a prosecutor and they would exercise some discretion or
that's why
give a
you
crap?
should have them. That's why. If we took away the minimum, they couldn't go, well, he's got to do 25 anyway.
That's what I'm saying.
I know, that's why we should take it away.
You know what I always wonder, and I see it sometimes, but why don't lawyers argue that the jury can ignore the enhancements?
You know, I was just going to say that.
You can, but some judges will shut you down.
Exactly.
Jury nullification.
You have a right, a defendant has a right to jury nullification. And you can argue to a jury, you have the power. Yeah, it's 25, but you can find that they haven't proven this beyond a reasonable doubt. You can find that if you don't believe it beyond a reasonable doubt. So even the evidence, I mean, lawyers don't argue. There are lawyers that do, and there are lawyers that win on that issue.
Yeah.
Right.
Trust me. There are lawyers that when they have a client facing 25 to life, they'll argue to the jury that you can ignore these enhancements. You don't have to find it because the government has to prove it beyond a reasonable doubt. We haven't heard any testimony. All we've seen is a judgment. We don't know if he's actually guilty. You know, you could argue that.
The problem is that it's it can be persuasive, but it's hard when you're the defense lawyer because throughout your trial you're saying, look, it's going to be tough, but can you follow the law? I mean, hey, man, everything happened except we haven't proved Harris County. Can you follow the law, juror number 3? Then you go to punishment. Follow the law except for now, right? So if there was something that allowed you to, but you shouldn't have to do that. You shouldn't have to do that you shouldn't have to always do that. I mean, that's why I'm arguing for the getting rid of the minimums. That way you could have the full sentencing range. Yeah, I mean, I think you should have.
Well, most lawyers in Harris County, from what I've seen, stipulate to judgments, when they get the punishment. They'll stipulate to the judgments anyway, which is ridiculous. Why would you ever stipulate to the judgments is what I argue. To say to your client, oh, he admitted that he did it, but you don't have to do that. And the jury doesn't know if he doesn't admit that he did it. They don't know if he doesn't stipulate. And so as a result, you tie your hands. If you've already stipulated to the judgments, the jury can't. They say, well, we know he's guilty. It's never thought of and never tried where they challenge the 25 to life.
We got our first call tonight. I want to jump in because there's clearly somebody watching us rather than the Rockets game. So I certainly want to get to them.
This person.
Hello, welcome to HCCLA Reasonable Doubt. Thanks for calling.
Thank you very much.
You have a question?
Yeah, I was on trial recently, and I didn't get picked on the trial, but I sat on it. It was a DWI third trial.
You were a juror?
I was a juror.
Okay.
Yeah, but I didn't get put into the panel. They didn't select me. But I thought it was kind of crazy because it was obvious based off of where we were that he had had a previous DWI because we were in district court. How do lawyers deal with that?
Good question. Thanks for calling. Jason, how do you deal with that?
Quietly pretend like it didn't happen? No.
Right?
You've got to address it. I mean, you've got to, I'm sure we've all got the same kind of similar story where it said, look, just because someone's committed this, is here, and he's a third, doesn't mean it's not evidence of this crime. But it is difficult because you know, same thing, like once a thief, always a thief, you must have done it this time. But you've got to address it up front because they're going to find out about it, right?
Well, because it's jurisdictional on that. In the caller's case, that's jurisdictional. In order to get to felony court, you either have to A, have hurt somebody or killed somebody in manslaughter, or B, this is your second one, and so you're here. So,
or a child passenger.
Or child passenger. But basically, you have to have something other than a DWI.
Yeah.
DWI plus something gets you there. I agree with Eric completely, but I want to counter that with saying it's also hard to say to your client, hey, listen, if you get found guilty by this jury, they may not find you guilty of your other priors that you may have not committed. And that's kind of a hard sell sometimes to say, yeah, they heard the case, they heard the evidence, and they found you guilty, even though, in my mind, I put together this great defense, poked holes everywhere I could, they found you guilty. But now when it comes time to find you beyond a reasonable doubt for your priors, they may not find that. I mean, that's a hard sell, and it's a hard sell both as an attorney, I think, and as a client. If you can do it, more power to you.
Well, I'm never saying say that to your client. I wouldn't tell my client you're not facing 25 to life.
Oh, yeah, of course. But
I tell them you're facing 25 to life. And then when it came time to punishment, I would argue the 25 to life. But in answer to the caller's question, I think in part, whenever you're faced with that, it's tough. But you can use it to your benefit by saying that the police in this situation may have responded to my client as if he's already guilty without even looking at the factors. They have access to see that he has a prior DWI. That's how they wrote up the charge and charged him with a felony because they knew he had these prior DUIs. So their presumption during their investigation was that he's probably guilty. So they started their investigation from the framework because he's got these priors that he's already guilty. And then everything that they looked for wasn't evidence of him not being guilty, but evidence that will confirm what they've already decided. So whenever you have those cases where you got a bunch of priors and they're jurisdictionals, that's an argument that you can make, is that, hey, that he is not guilty of this offense, and the only reason he really got charged is because he had stuff happen in the past. And you spend time in voir dire talking about a defendant who's done something in the past. Person did that in the past. Let's judge him based on what he did now. And,
right.
and you know, the police have this presumption and they're against him. You can actually use it as a sword instead of, you know, being on the defensive. If you're explaining, you're losing. But if you can get it to a point where you're using that and putting them on the defensive, say, hey, look, you're presuming him guilty because you knew he had these prior DWIs. You didn't investigate this case the way you normally investigate a case. You didn't look at this case how you would normally look at a case because of his priors. You know, it could become a theme of your case. That'd be a one way of
Stealing that
attacking.
idea, by the way. That was good. I'm stealing that.
We got another
Feel free,
caller
I'll
on the
see you
line. I want to get to our next call. Hello, welcome to HCCLA Reasonable Doubt. Thanks for calling.
Hey, hey guys, it's Tyler Flood.
Hey, Tyler.
How y'all
what's going on?
doing?
Tyler,
We're doing great.
That's a great question for Tyler.
Tyler, are you not wearing your red Rockets jacket tonight?
Not tonight.
Dang, Tyler's actually here right now.
He's right there.
Talked about the last answer.
Yes.
I agree with that completely. That officers are trained to look for signs of intoxication. They're trained to look for evidence of guilt. They're not trained to look for evidence that other than guilt. They're focused solely on trying to find evidence of guilt. And when they hear about priors, when they run somebody, they already know that, and it's in the back of their mind, and they cannot put that aside. The person's going to be arrested no matter what, especially if they hear about two prior convictions. So another way to deal with this, though, I've had a lot of success trying felony DWIs. I haven't shied away from trying them just because you have to deal with the two priors. And we've had great success getting not guilties at trial just based on the merits of the case on trial. And the difference I've found is that in misdemeanor cases, you might get 20 minutes, 30 minutes, some arbitrary time limit that the judge gives you. You're supposed to cover all of your important issues in an arbitrary 20 minutes. But when I've been able to try a felony DWI with two priors, I can get an hour to 2 hours, and there's no time limits.
Now, you're talking about voir dire, though, right? You're talking about you get that much time of voir dire.
He's talking about in
Yeah,
voir dire.
that's what I was
Right.
saying. Jury selection.
Yes.
Yeah.
Yeah, hope not closing.
If I can spend 2 hours with 60 people, I have. You can find the people that won't be able to set those aside. You can get real conversation going with people that will say, you know what, eventually you will get them to open up and tell you the truth and say, you know what, I cannot set those aside. So
Yeah.
every time I've had this happen, we've almost gotten to the very end of the 65, 70 person panel, but we get fair juries. As long as you have enough time to cover those issues and to ask them if they can set aside those priors, I think you can get a true panel of 12 people, but you've got to have enough time. And we spend the majority of the time talking about that. And I tell them, I just say, look, I'm like you. Human nature dictates that I would think if they did it in the past, they did it again. And you open up and you make them feel like that's what human nature dictates and that's your gut reaction, and then have a real conversation with each one of them individually, not just as a group, not just, hey, first row, raise your hand, but you talk to each individual juror, and you can get down to the people that will tell you, I can't set those aside, or I can. And in my experience, the ones that have said after all of the questioning that they can set them aside, they truly can, and they have, and they're able to judge that case just on the merits of the case on trial. So I think those cases can be tried and won. You don't ignore them. You confront them, and you just tell them, say, look, I get it.
You know, I think, Tyler, that's true in every case where you have prior offenses that are jurisdictional. What you said is true in all of them. I would almost argue that it could be used as somewhat of a blueprint in trying cases where you have felon in possession cases, same kind of situation. There are a lot of panels that you can bust based on those questions or questions related to that, or you have people who couldn't be fair, you know, in most situations. So I think what you're saying is absolutely true.
Yeah, people who basically can't follow the presumption of innocence.
That's
You're
right.
talking about people who are on a death penalty case are people who can follow who can assess the death penalty.
Not just follow it, who are ready to give it.
Ready to give it. I mean, we're looking for people in these types of cases who can absolutely 100% follow the presumption of innocence to a T.
Yeah, now you'll always, individual voir dire is important, and I think it's important because you'll always have people who are trying to sneak on a jury,
Well,
you know, who want to do justice in their mind.
absolutely.
And they know that they can't set it aside,
No
but they
doubt.
want to sneak on a jury so they can hand over a little justice to
We
the
have a
defendant.
joke in our family that my grandmother never let a defendant get away when she was called to jury. So, you know, but Tyler, thanks for your call, Tyler. We really appreciate it.
Thank you, random anonymous caller. Great.
Eric, you kind of mentioned something. I know voir dire is important, but how important do you think it is to have no time limits on voir dire, be it felony, misdemeanor, or whatever?
Oh, I think it's beautiful. I'd like to know who the judge was that Tyler tried the case with that gave him no time limit on voir dire. But because in Harris County, most of the district court judges, there are a couple of visiting judges that'll come in that'll do that. So he's right. There are a few that will do that. And I think sometimes in some cases, Judge Barr will give you more time. But most of the judges in Harris County will put time limits on you. And do I think it's important? It's absolutely important. Absolutely important. What I've been able to get is like an hour to an hour and a half of voir dire. I haven't gotten less than an hour, but I haven't really gotten more than an hour and a half for voir dire.
So let me ask you another question. Do you think it's a good idea? So in capital murder cases, in capital murder death, you have individual voir dire per person, right?
Right.
I don't think that's a good idea for cases at large, but do you think it's a better idea to, instead of having a 60-panel jurors where you're trying to talk to 60 people in one room, maybe having 60, but you talk to 5 at a time or 10 at a time, to where you can have a more individualized conversation and more time with those jurors?
Well, I think it's a good idea. I know in Florida, for example, they do more individualized voir dire. They actually have a panel of people, and they'll take them one at a time, and they'll work their way down. And each side will make their strikes at that point in time with one juror. And so it's a little different. You have more of an individual conversation with jurors. You do some generalized voir dire depending on the judge. So I think, and I would agree with you, I think that it can be cumbersome if you have too many people. But even in Harris County, you have variances in how judges do it and how they conduct voir dire. For example, Judge McSpadden and Judge Catherine Evans, they're two that I know, they will entertain challenge strikes, or at least challenges for cause, immediately. Right after it becomes manifest that a juror is challengeable for cause, they'll let you strike the juror at that point in time.
Really, I don't like that.
Yeah, well, I like it. I like it only because it's a great use of time. Because once you know that you got a juror that's gone for cause, now McSpadden, he tells them, you're excused. This is what he tells them. He says, you're excused from service. So that person gets up in the middle of and walks out of the room in the middle of our day. Now, his reason for doing that is if somebody doesn't really want to serve and they have an issue where they can't be fair in a trial, they shouldn't serve.
They shouldn't poison the rest of the jury.
Well, think about it. If you got somebody that doesn't really want to serve on a jury, right? Even if it's a situation.
Well, I'm not saying I'm okay with him kicking them out, because if they keep talking, they're going to poison your pool. But,
that's true.
That's the
true.
one thing. We got another call coming in.
To a degree.
We got another call coming in. I want to take this because I hope it's not an ominous sign that the Rockets are losing, that people are not calling. So, hello, welcome to HCCLA Reasonable Doubt.
Yes, hello.
Hi.
Hello?
Hello, how you doing?
We're doing great. How are you?
I had a question. You guys are talking like using real big lawyer words, and I don't understand all of them.
Sorry about that.
It's okay. I heard y'all talk about the death penalty earlier.
Yeah.
Okay, so this all fine and dandy. I know y'all are criminal defense attorneys and y'all represent people, but I would like to know if each one of you guys, if something happened to your daughters or son and they were brutally injured or something, would you be for the death penalty on a personal situation?
Well,
It's one thing is to represent a client, but would you guys be for it? Because that's the thing. I don't like when I hear about people being executed or who shouldn't have went to jail, but I think if something happened to my mother or something happened to my sister, and I don't want that person to die. How do you guys feel about that?
And that's a great question. I appreciate your call, and I'd like to go around and get everybody's opinion on that, because I know for me personally, I often say that...
Like Michael Dukakis.
Well, I mean, look, I'm not worried about it.
Yeah.
I mean, our opinions are our opinions. I don't have a problem with the death penalty, frankly, because I do believe that there are some people, especially on, like I said, I think terrorism cases are the exception. I mean, I wouldn't hesitate to put somebody who did what he did in Boston. I wouldn't hesitate, and I'm not ashamed to say it. I am a defense lawyer, and I'm not ashamed to say that, because I do think there are some people that, based on their actions, they don't. We shouldn't give them a second chance, and I don't think we should just keep them in a supermax prison in Colorado either.
You know, Jimmy, I agree with you to an extent. The human side of me wants revenge under the Carlos hypo, and so the Damon side of me says, yes, I do believe that some people forfeit their right to live based off their crimes. I do believe that. However, the Christian side of me, which I like to believe is a more controlling side, recognizes there was this guy who called Saul, who God turned into Paul. And Paul wrote most of the New Testament. And so we have the idea, at least I do in my heart, that people can change and they should not spend the rest of their life based off the sum of their crime. So whereupon me, Damon, would say, yeah, go ahead and kill him, I like to believe I'd be true to my faith and say, no. Even though I am hurting and I'm upset and I'm in a lot of pain right now, I don't think I'm going to feel better with this person not living. I won't feel better with them dead in jail either. I'm in pain, but I think I would still be against the death penalty. At least that Christian side of me, I think I would still be against it.
Eric, what about you?
I mean, in Houston, or at least in Texas, the death penalty is the law.
Yeah.
I mean, it's simply it. And most Christians, a lot of Christians will be pro-death penalty because there's actually some scripture that says to, respect the law, to respect the authority, etc. So,
that'd be Old Testament.
Well, no, it's New Testament, actually. It's in Romans chapter 14. It talks about respecting the law. So in the New Testament, there's actually a scripture that talks about that and respecting authority. And so that's why you have a lot of Christians who are actually pro-death penalty because of that. But still, abortion is the law, right? A woman can legally has a right to choose. Some Christians have problems with that as well. So morality and the law are two different things to a degree, right? Mm-hmm. But I will acknowledge that the death penalty is a law. And I think I could serve on a death penalty jury because I believe that the death penalty is a law and I could follow the law. Now, do I have a problem with the administration of the death penalty and how we do it? I think there's some issues with the administration of the death penalty. I think there's some things there's some factors that aren't always considered, and I think that there's some factors with some of the way some juries do it. You follow me? I think those are all issues that are a little bit different. So you won't hear me say that, oh, the death penalty is morally repugnant. It's what the law is. is what the law is right now. And I will say this, I think that there's some serious issues with how the death penalty is applied in the country. And I have a problem with trying to execute an innocent person. So if I think that there's somebody who may be innocent in a situation, then I wouldn't want to do it.
Well, I think we all agree.
I think we all would. And I think we have executed some people who have been innocent. And so that's why I said I think that the way we are doing it is not correct. Now, does that mean we should have a moratorium on the death penalty until we figure out how to do it right? I mean, that's not the law.
Yeah.
I don't think, separating how we feel individually and what the law is, I mean, sure, there's situations with the death penalty. I would wish someone's death if they'd wronged me in a grievous, heinous way, but whether I'd want society to have the death penalty is a separate issue. I agree with Eric that the real problem is that there's not a way that society has not found a way to administer the death penalty fairly and justly across the board with respect to disparities in racial application of the death penalty or whatnot. And that to me is a large reason why we shouldn't have it, because we can't fairly apply it. We're flawed human nature. We can't do it. But yeah, I agree there's going to be situations with the death penalties probably is going to be appropriate, but I think as a society we apply it way too often. I mean, the Romney situation might be the one example, Hitler the other example, but
look, the caller said about our feelings, and I don't think that any of us at this table, just because we're lawyers, can separate our feelings sometimes. I mean, what's the first thing you say in jury selection when you tell the jury you may not be the right person for this jury? And kind of what I use as an example sometimes is, if this were a situation where, for instance, my grandfather, he passed away in a truck wreck. And I tell people sometimes in jury selections, if this is a trucking accident, I may not be the right person to sit on that kind of jury. So I think the caller makes a point is that, here we are talking theoretical about it, but at the same time, if something did happen to one of our family members, I don't know that any of us know how we would react necessarily.
I think we would all be hurt and upset and want
revenge.
For sure. I don't discount that. And I think we would all follow the law as we try to do it on daily practice. So I think
it goes to what shoes you're in, whether you're in a jury shoe, whether you're in a victim shoe, whether you're in a defense lawyer's shoe. What shoe are you in?
If something, depending on if it was some heinous crime that was inflicted against one of my family members, I would hope one of you would represent me. You follow me? I would hope that one of you would represent me. Yeah. You get what I'm saying? Yeah. And that's sort of how I would feel.
Right.
I would be honest. That's honestly the truth. I would hope one of you would represent me. I would want to show compassion. The good side of me would want to show compassion, would want to show mercy, and would want to show forgiveness, and not be retaliatory, and not try to seek retribution. So I think if something happened to one of my family members, I would try to be the better man and realize that killing that person or that person being killed by the state won't bring back my family member.
Right.
Won't bring back my family.
And that's the point I'm making right there, and that I would definitely want retribution. I do believe you can forfeit your life, not even with the mass killing. I think you can kill one person in a certain way, and you've lost your right to live, be you 18, 19, okay, because 18 to limit 18. But I do think I'd have a conflict with that because I do try to practice forgiveness as well. Sure. So I mean that's an issue. I don't think anybody's really against the death penalty. They're just always
guys, we got to wrap it up. Unfortunately, we're out of time. I'd like to get more of your thoughts though, Eric, but
no, it's all right.
We're out of time.
We have an extended version that's available on the web or something.
Yeah, we're gonna go. we're gonna
uncut version.
We're gonna have the after hours version of Reasonable Doubt over on Twitter. But I want to thank you guys for coming on, Eric Davis, Jason Luong. We appreciate you guys coming on and having a great discussion tonight. And Damon, we'll be back next week.
Mark Bennett.
Same bat time, same bat channel with Mark Bennett, of course.
Right.
It should be a good time. I want to thank all of our viewers and everybody writing in on Twitter, and those of you who called in, we really appreciate it. Follow us on Twitter at HCCLA_TV. You can also go to our Facebook page and like us on there and keep up with all the updates of the guests and the topics and everything else. So for Damon Parrish, good night, everybody.